Welcome to The Law Matters. Of course it does. Hi, I'm T.Morais, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect your family, yourself, and your business. We provide information and resources that'll help you determine whether or not you want to contact a lawyer. Perhaps you'll be prepared and decide that you can handle some issues yourself. If you do need professional counsel, they'll be better prepared, and so will you. Either way, you'll save time, money, and hopefully achieve better results. The Bazar and Associates law firm in East Providence continue to offer their insights, experience, and expertise on the various issues that we tackle, and we want to, as always, welcome once again Attorney David Bazar. So today, every year, there are products that have allegedly caused harm and death to consumers. The headlining culprits and cases are very wide-ranging. Most recently, we've heard of Hoverboards ablaze. Plavix continues to have issues with misleading marketing, and now some questions about jurisdiction. Prilosec has kidney damage issues. Zoloft has some impact on causing birth defects. Baby powders causing cancer in women. Even General Motors has some issues now that's been continuing about a bankruptcy that's now causing a loophole and shields it from the defective ignition switch that had been an issue for it for a while. So product liability and personal injury is something that matters, and it's something that often is as a prolonged issue. We've noticed that consumers and attorneys with some of these issues are paying particularly careful attention to what's going on. We've touched on some of these cases previously. We'll do it a little bit more now, but appeals and added victims, added costs, it keeps all of this in the news. So what is it that you need to know? We'll explore that. What constitutes product liability? Who's at fault? What happens when there's a cover-up? So, counselor, what is product liability?
So generally speaking, when someone's injured by a product that's defective in one form or another, or there's a failure to warn, and that negligence or defective product or whatever it might be causes an injury, and it's based on the product's design or manufacturer, there is a potential for a product's liability case. So a product liability case is actually very interesting because it can take on 3 or more different types of legal claims. A product's liability claim can be based in contract. And in contract law, you usually would base a product's liability claim on either express or implied warranties. And so that usually makes me think of car situations. And so you mentioned GM, but all cars have airbags in them. And we know we've had trouble with the Takata airbags and some of that. So how can you then have a claim based on a warranty in that situation? Well, there's an express warranty that the car is going to work in the way it's supposed to work, but there's also an implied warranty that the car is going to be designed and work in a way that is safe, and it's sort of an implied warranty of merchantability, that it's going to be good for what it's designed to do. So in this case, the airbag is designed to prevent injury, and it's supposed to work in a certain way. And if it's not working in that way, there's a breach of that contract, and you can sue based on that.
So when you talk about the product liability and defects, I guess that's part of personal injury, it's part of tort law. There are different kinds of defective product liability you started to touch on, and if you would explore a little bit more design and manufacturing.
Yep. Okay, so the airbag, we can still go with that. The other types of product liability claims, it's all the same injury, but it's what claim are you going to proceed on, what's the easiest to do. So you mentioned tort law. Well, negligence obviously is a big foundation of tort law. So if there's a product, the airbag for instance, and the company was negligent in how they put it together, which would be a manufacturing defect, or how it was designed, a design defect, you can sue on negligence. That's a little tougher thing to do because you have to prove certain elements of negligence, which we've talked about before, which is that there's a duty, there's a breach of the duty. As a result of the breach of that duty, there's causation of the injury that was incurred. It's sort of like an ABCD, a duty, A, breach of the duty, B, causation, C, damages, D. So that's another way to proceed. But in products liability, we actually have what's called strict products liability. And that is if you can prove that a product entered the stream of commerce in a way that it was defective, and as a result of that defect caused an injury to somebody, then you can proceed under direct strict liability for the product liability. So it's a little bit easier than having to prove the negligence, but you still have to prove the defect. So there's still an awful lot that goes into it. So let's talk a little bit, is what you asked me to do, is the difference between a design defect and a manufacturing defect. So if the problem with the airbags was they were designed incorrectly so that they didn't operate the way they were supposed to, even though they were made in accordance with the design standards, that would be negligence because the design doesn't work. If it was a manufacturing defect, then one of the components, which is actually the case in this situation, doesn't work the way it's supposed to work, then it's a manufacturing defect. And I actually tried a case a long time ago, which was about a manufacturing defect. So the story goes a little bit like this. I'll tell you how old it is because you have to remember Allmax stores. Do you remember those way back when?
I do.
Okay. So Allmax stores were at that point in time in Rhode Island probably 60–70% of the grocery market in Rhode Island. And my client went in to buy a bottle of apple Lincoln juice. Apple Lincoln drink. It was in a bottle designed and made by Anchor Glass Manufacturing Company. When she went in to get the juice, she picked it up and she tilted it to put it into her shopping cart. And when she did that, the bottle just disintegrated in her hands and a spiral fracture came down and sliced right through her leg, the muscle, the tendon, the nerves. And she was in shock. She put the top of the bottle down. You know, the old spill on aisle 2 goes over the intercom. They all come running. It's so bad. One of the managers described it as a war zone with blood everywhere. He closed it off. So what they did was they swept up all the glass on the floor. And after a short period of time, she contacted us. We hired an expert in metallurgy, because glass is sort of a metal and has the principles of metal, from Brown University. And we contacted Allmax. They had put the glass in a box and put it in the manager's office and locked it so no one else could get to it. He went there, the manager let him in. He took the glass, he went through, he put it back together, and what he discovered was when the glass was made by Anchor Glass Company, it went through the mold, and the mold was too hot in the neck of the bottle, and so it caused it to run too quickly, so it was too thin in the neck. And the reason it didn't become an issue until she got it was because they made the box that the glass went, well, they made the glass went into a box, case of Apple Lincoln drink, empty. It was then shipped to the bottling company. They filled it up in machines that picked it straight up and put it straight down back into the box. It then went to Almax, where the person stocking the shelves took it straight out and put it in the shelf. And it wasn't until she lifted it and leaned it, so there was weight from the juice in the bottle, that the defect became apparent and caused the injury. So we went to trial on that case. And who did we sue? We sued the glass manufacturer, we sued the juice manufacturer, and the store, because they're all in the stream of commerce and they're all in the process of selling this defective product. And it was important that I did that because at trial, one of the defense attorneys objected to my expert testifying as to what he did with the glass, because he wanted me to prove that it was the same glass that caused the injury. And if I had let Allmax out, because they had someone watching the trial who was their risk management expert, I wouldn't have been able at that point in time to prove it was the same glass. But since they were still in the case, I was able to call the risk manager, put her on the stand, and have her testify to the chain of custody of that glass, and that it was the same glass. They weren't storing any other pieces of broken glass in the building, and that it wasn't looked at until my expert came and got the glass. And so we were able to get over that hurdle. But the point is, in general, that anyone in the stream of commerce who is responsible for selling that product can be held liable for the defect and the injury that it may cause.
And in varying degrees of blame, I guess. There's certainly, they would say there's enough blame to go around. who ends up having, who gets sued for the highest amount? The one with just the deepest pockets, or where's the source?
Well,
is it at design? Is it at manufacturing? Where, you know, Almax technically just happened to be one of the distributors of said product.
So it all depends on the situation and what contracts these companies probably have with each other, because oftentimes there is contract that covers, you know, if there's a defect in the bottle, you, the manufacturer, are responsible for it. If there's a problem with the juice, you, the juice manufacturer, are responsible to Almax, the ultimate seller. So in that particular case, since the defect was caused by the glass company, that's who ended up paying. And they indemnified and held the others harmless as to that defect. So they were ultimately responsible, but to the consumer, they're all responsible. And so that's why it's important that they're all included. I had another case. This was a case that involved, if you ever saw these sneakers that have rollerblades that pop out of the bottom. So
Yes.
the manufacturer was in China. The distributor was in China. The seller was in Rhode Island. And it was a large retail outlet in Rhode Island. And they sold these defective shoes that my client bought. And how were they defective? Well, when the rollerblade comes out, it's supposed to have a spring action that locks it in place. And in this particular case, on one of the shoes, the spring didn't work, so when you were going along, it would just go back in. And when it went back in, my client fell and broke her leg. And you could say that there might have been some assumption of the risk for someone getting on one of those things, but that's another story which we can talk about defenses at some point in time. But in this particular case, I'm just trying to highlight why it's important that all of these people are responsible. And the reason is, in this case, the seller, the distributor, and the manufacturer from China couldn't be found. They couldn't be, and I don't know if they had other claims and they just went out of business, but we couldn't get to them no matter how hard we tried and what process we went. So the seller, the retailer, became ultimately liable to my client.
So without going through the defense of the case, how about the issue about perhaps the product wasn't used properly? Well, if she was just rollerblading, then it may not have been an issue. How do you determine whether or not someone who comes in with a consumer complaint, whether or not it's a legitimate claim?
So you are talking about defenses because misuse of a product is a
Right.
defense to a product's liability case. Assumption of the risk or comparative negligence
Okay.
can
the point, okay.
can be a defense to a case. In Rhode Island, we actually have a case that's the leading case on comparative negligence in products liability, and it was a case that was actually tried by an attorney who's since passed, Lenny Dekoff, who was really the dean of products liability in many senses for the plaintiff's bar in Rhode Island. And in this particular case, a football player was injured when the helmet snapped down on his neck and paralyzed him. And the defense raised the issue that he had been taught how to tackle wrong and that he in fact tackled wrong in this instance. And therefore, if he hadn't done it incorrectly, he wouldn't have been injured, or at least his negligence was a contributing factor to the injury. The defect was the way the helmet was designed. If it had been designed differently, it wouldn't have snapped down and broken his neck. And in Rhode Island, the Supreme Court says that comparative negligence, even though it's called strict liability in products liability cases, can still apply. And if you can prove that to a certain percentage the plaintiff caused his own injury, then that can be deducted off of his damages. And so there is some defenses along those lines. But misuse of the product in that case obviously doesn't apply because he was
Correct.
using it for what it was designed for. A misuse of a product could be using, well, you talked about prescription drugs, for example, and if they're designed to do one thing and use them, they call it off-label, to do something else, that might be misuse of a product. Or you see it often with power tools.
So touch on one other aspect of this too before we get into, I would like for you to lay out what a case looks like, but when they talk about the misleading marketing, that's an aspect of the product liability, but can you tell us, is there a difference when you approach a case in terms of how it's going to be handled or what the reparation is going to be if it's just mislabeled marketing or misleading marketing versus strict liability, as you're saying?
So there's a third way of proving a product's liability that doesn't have anything to do with the manufacturing defect or the design defect. It's a failure to warn. And we saw that an awful lot, both in automobiles and in ladders. And if you ever get on a ladder, oftentimes you'll see a warning now on ladders that say the top is not a step and not to use it, or to use the ladder in the way it's designed. In other words, don't lean it up against a thing, a building or a side without having proper people there, or use it in the way it's designed. Don't misuse it. But certainly in cars, you can't get into a car these days and put the visor down without seeing a whole host of warnings, which could be from airbags are very dangerous with young children. Young children need to be in the back. They can't face an airbag, or a whole host of other warnings. And those are all because products liability allows a claim to proceed for the failure to warn. So slightly different from the description you were giving where there's misleading information giving, but it's the same type of idea.
Which was the Plavix issue. Give us the anatomy of a case. Some of these that I've just mentioned at the top of this segment really have reached the class action state.
Right.
But with the situation that you describe with some of your cases, what's the anatomy? When someone comes to you and says, David, I think I have a case here, how do you approach it and what are the steps?
So a products liability case can be brought on an individual basis, but if you're going to do that, it's going to have to be for catastrophic injury because they are expensive, just like a medical malpractice case. If there isn't a catastrophic injury, most lawyers aren't going to invest the time and, more importantly, the money that has to go into proving that case. So for some cases, as you're talking about, and those are the ones you see if you stay up late at night and advertise from national law firms, are done in a class action form. And it's where there's some injury or some problem with the product, but it doesn't reach the level where an individual probably would want to bring the claim, or an attorney would take the claim to bring it individually. So some of those drug cases, or mesh, I think I see a lot of advertising for hernia mesh and things like that. These bigger national law firms have the cases already in place, sort of like a stamp them out factory style kind of thing where they can fit them in. Some cases you have to bring that way because of bankruptcy, which you mentioned at the beginning, and the types of case they are, which, like, for example, asbestos cases. John Manville Company filed bankruptcy, a lot of money went into a fund, and you have to proceed against that fund in a certain form or fashion. As opposed to, we had a case that came in just a little while back where a woman was severely burned when a propane tank exploded. And there were a number of other aspects to that case, and I love that family, and unfortunately the mom died, but the daughters are the clients, and I love them and I'm very close to them, but I told them that from a legal perspective, it's like a law school exam. It's a final exam because it has so many different components to that case. Someone on a motorcycle hit the tank exploded, so there's issues about the person on the motorcycle being negligent, perhaps. There's homeowner liability because of where the tank was placed and where the people were allowed to sit in relationship to the tank and the pig roaster. It was a pig roast. And then there's products liability on the tank itself. And in that particular instance, the tank was defective, the way it was designed, but the company that filled it up should not have filled the tank with gas because by looking at it, it was illegal for them to fill the tank without the safety equipment that should have been around the tank. So there are all sorts of issues that can go into that. And it's really the lawyer's job to look at that case and analyze the case and say, here are all the different things that we have to investigate and go out. So we needed an expert to go look at the tank. The expert was hired immediately. Yes, there's a defect in the tank. As it turns out, there may have been a defect with the motorcycle too. So now we have to go back and look at that because apparently, although we thought initially the fellow driving the motorcycle may have been negligent, it may have been the bike was defective and the throttle got stuck open, and that was what caused him to lose control of it. So now the motorcycle needs to be looked at. So it's a whole host of things that come into a case that you may, at first blush, not think about or recognize as either a layperson or as even an attorney if you don't do a lot of these types of cases.
So you have to go and consult with each of these expert witnesses to determine even who can be sued and where the onus should be.
Correct.
And then what happens next in a case, if not this one that you use an example, what happens
Well,
next, David?
I won't use this one per se, but I'll just, as a general hypothetical, if the experts look at the tank and they say, this tank is negligent, we'd have to find the manufacturer of the tank. If they say, well, the tank is a certain age and the manufacturer either no longer exists or you're not going to be able to really go after them because of the age of the tank, but the company that filled the tank shouldn't have done that, that's your next avenue. If the motorcycle was defective and there's a manufacturer of the motorcycle, obviously that's where you go. If it was one that had been put together from different pieces and parts from different things, and there's a component in the motorcycle that was defective, then you have to sue the manufacturer of that component, perhaps, if it's not just like a Harley Davidson and we know who to sue. So those are all the things you have to do. Now also, of course, in the case, because the negligence, the product's liability is one aspect of the case, but it's still in personal injury case, or in this case now a wrongful death case, if we're talking about that case, you still have to put all your damages in place. So you've got the medical bills, the pain, the suffering, and all of those things you have to prove. The loss of society and companionship with the survivors, the children, or the spouse if there was one. All of those things need to be put into place.
So as you're describing this is a long process. Meanwhile, there are some imminent needs that are need to be addressed, like how is this person's medical bill being taken care of and some of the other support issues. Who is watching that? Who's taking care of that? You're making sure that it's taken care of. Who do you end up going to?
Well,
how does that
there's
work?
a lot of different things that go into it. So you work with the family. If the person has medical insurance, you're making sure that the medical insurance is covering what needs to be covered. If it's a situation like this one where there are multifaceted pockets of negligence, you might say, well, there's MedPay to help cover some of this. Or you might say, if it was a Massachusetts case, there's PIP coverage, personal injury protection. So you might help push people in certain directions. Of course, given every situation is different, but if someone was working, you know they're not going to be working for a long period of time, you want to make sure that they know that there's Social Security disability that might be available to them, or in Rhode Island, TDI. So all of these things you help the family with.
Clearly, from what you're describing, we know this is not one of those do-it-yourself, handle-it-yourself kinds of situations. And obviously, this can go on for a long period of time. Many of these cases, if you're representing an individual, they settle out of court rather than going into a full trial, or how does that play out?
It depends. You know, many times these cases do not resolve without filing suit, and the discovery process has to be gone through, and then negligence may have to be apportioned, or there may be joint tort fees. There might be a lot of different issues that go into it. Some pieces of it may settle as it goes along. It may never settle. It may have to all be tried because of the complexity of the case, or it may be resolved at an arbitration or mediation, as any case can be.
So to just touch upon one of the newer issues, the hoverboard, which doesn't literally hover as we know, it doesn't work like that, it rolls. They've had many issues. They catch fire, they explode, and so there's a design issue, there's a manufacturing issue. Now apparently there's an issue about them having a certification, a UL certification, that saying it's less likely to blow up if it's properly batteried and properly taken care of. So what happens in a situation once they've found that it was not properly done, there were suits? Now that they are supposed to be making them with the UL certification, there are people who are undercutting them and not doing that. Who gets to sue what? If it was a knockoff and they didn't have the UL certification, if you are hurt, do you get to sue that company for not manufacturing it properly? Where does that stop, and how does that play out, David? There are so many issues with the hoverboard, including use.
Right. So if the negligence is in the manufacturer and it's because they didn't use the correct batteries that UL says this is what you should use, then obviously you're going to want to sue the manufacturer. But here's the problem. It's the same thing with that girl with her sneakers and the rollerblade. it may be made by some knockoff company in Japan or Korea or elsewhere, and we can't find them and you won't find them. So you're back to suing the retailer who sold them to you. And again, the stream of commerce is the key to products liability. If a defective product is put into the stream of commerce, everybody who touches it along the way and sells it can be held liable. So it's a matter of finding out who sold it. And then, of course, again, preserve that board so that you can bring it to an expert to show that it doesn't comport with what Underwriters Laboratory UL is saying it should.
And of course, there's also the issue about the person who's using it. Okay, if it doesn't blow up and explode, but someone gets hurt. That happens. That happens with bikers or whatever. But there are safety issues now about where you're supposed to ride and where you're not. There are laws about sometimes you can be on a bike path in California, but not in another state. There's a helmet situation. There's how you, what grade of incline you're either on or going down. So isn't that very hard to prove? If someone gets hurt, sure, I had a helmet on. You don't know. No one took a picture. How do you defend against all of those variables? You described other variables in cases. How do you deal with that?
It's the comparative negligence standard. You, as the plaintiff, have the burden of proving the defect in the injury. Then the defendant can say, well, wait, you misused the product or you were comparatively negligent. So that burden actually comes to them to prove that. So going back to that ladder case, if you went up the ladder and the ladder had the warning on it that said, don't use the top of the ladder, it's not a step, and you go up there and the ladder goes out and you go down, you can prove maybe that there was, even if you can prove that there might have been a problem with the ladder, if they can prove that you misused it, that's a defense.
With so many of these pharmaceutical cases, and we don't have much time to talk about them, but there's so many now in the news, whether it's Plavix, Prilosec, and various others. Because they're in the news right now, if someone uses these products now and ends up with one of these kidney problems, cancer problems, or whatever else, do they still have any recourse, or do you end up saying, well, see, it's been in the news, the onus is on you as the consumer to choose not to use them, because even though the doctor may say the benefits outweigh the side effects, right, you bought it, you decided to do. Where's the onus?
Well, it's interesting, but if you take a quick look at the ads for anything for drug-related now, you're always going to see, the side effects. And if they're well-known side effects and you and your doctor decide to take them, that can be a defense.
Good to know. I imagine that they're still going to be coming back at you. We hope that some of these issues have been helpful as you think about how you use products, what products you choose, and we hope that you'll continue to stay in tune to the law matters, because it certainly matters to you. Thank you for tuning in.